Once again, welcome back to the Continuing Legal Education program of the Seminar Committee powered by the Bar Council of Kerala. As all of us know that we have Continuing Legal Education program, we have conducted sessions continuously for 60 days, and thereafter we have shifted for weekly sessions. And today we are on 81st day of our this Continuing Legal Education program. Today we have a very senior lawyer from the brother state, and he is a practicing lawyer before the Madras High Court of Madurai bench. Sri Advocate Srinivasa Raghavan is not only a lawyer, he is a poet, literature. He is having some other works, conducting this web series seminars and sessions to the legal fraternity and the legal aspirants. And also he is a member of the Judicial Academy of the Tamil Nadu. Recently, one of his book was also released, which includes the poems also. So the topic of the day is the paternity, presumption, and the personal liberty. In fact, it is covered under the Evidence Act, Section 1 and 2, and also the Article 21 of our Constitution. So it will be, we hope that it will be very useful to the practicing lawyers, as nowadays the cases on such areas are, especially in family court cases, such we have to face such legal issues in the court. So I express my sincere welcome to our faculty guest, senior lawyer from Tamil Nadu, Sri Srinivasa Raghavan sir. For on behalf of the Bar Council of Kerala, I express my sincere welcome, not only for the Bar Council of Kerala and also for the participants here. Sir, welcome, sir.
Thank you, sir. Thank you very much.
Now I express my sincere welcome to the chairman of the Junior Lawyers Committee, Sri Moideen sir. From the very beginning onwards, without missing one of the session, he is participating in all along the way, and also he is giving all the guidance, and also he is sometime he will be the host of this program in some other days in the absence of the other required members. So I welcome Moideen sir to this platform. And now I want to welcome the chairman of the Bar Council, Sri Joseph John sir, and all other members who all are participant in this webinar, and also we hope to join in this webinar series. Now I express my sincere welcome to the Assistant Secretary, Sri Shivaraman, and also to Advocate Shami, who is the technical advisor or technical coordinator of this webinar series. So, and also expressing my sincere welcome to all the participants who all are here, present for having hearing the lecture of our learned senior Sri Srinivasa Raghavan sir. And thank you very much. And I request Sri Srinivasa Raghavan sir to continue the class, and the platform is yours, sir. Thank you.
Thank you, sir. Thank you very much. First of all, I just thank the Bar Council of Kerala for extending the opportunity to me. And it's a nice experience to share the platform with our neighboring state, who have a lot of things to share in common. And I thank one and all in the Bar Council who are in charge of the program, and thanks once again. See, as the title would suggest, the issue of proving paternity is getting more complicated as days go by, not only because of the contradicting judgments of the courts across the country, but also on account of changing phase of science and technology. Just imagine when Section 112 of the Indian Evidence Act was enacted in 1872, we did not even have the blood test in force. But now the times have changed. We have the latest technology in our hand, available at the click of a mouse. And can we shun our eyes for such technical advancement? If that be the case, what is the march of law? Whether the Indian courts are open to such scientific developments, whether we are going to destabilize the institution of marriage, are we going to extend our welcome to the science and technology, at the same time we encourage bastardizing the children for the fault committed by the parents? All these questions are hidden inside the topic. So let me just move to paternity, presumption, and personal liberty. As Mr. Pramod has pointed out, the dispute revolves around section 112 mainly, but there are some incidental provisions also. We'll come to it a little bit later. So the subject matter of the discussion, as it suggests in the screen, revolves around the dispute as to paternity of children. Such a dispute may arise in very many litigations. It might occur in matrimonial dispute before the family courts. It might occur as a defense in a suits for partition where the father denies the legitimacy of the son to claim a share in the ancestral properties in case of Hindus. It might come into operation in section 125 CRPC matters. It might have a role to play in even succession certificates. So the issue of dispute as to paternity is not confined to any single independent litigation. You can take the example of N.D. Tiwari's case, where a son has filed a case against the father for a declaration that N.D. Tiwari is the biological father of himself. There are suits under Order 32 of CPC in the nature of declaration of status. So the test that is contemplated and that revolves around the dispute is the DNA test, more importantly, because blood test is no more advanced, precise test. So as I suggested, the relevant provisions of law governing the topic are the most important Article 21 of the Constitution of India. Incidentally, Article 20, subclass 3 might also come into operation, and sections 4, 112, and 114 of the Indian Evidence Act. We'll just see the provisions of law before going to the deliberations. As we all know, section 4 of the Indian Evidence Act has got presumption. They have three kinds of presumption. The court may presume, the court shall presume, and the third is very important, conclusive proof. What is meant by conclusive proof? When one fact is declared by this act, that is the Evidence Act, when one fact is declared by this act to be conclusive proof of other, the court shall, on proof of the one fact, regard the other as proved and shall not allow evidence to be given for the purpose of disproving it. So there should be two facts. One fact is proved, and when it is proved, the court shall presume the another fact as the conclusive proof. And the result of drawing or inferring a conclusive proof is simple, that the court cannot invite contra evidence once it comes to a conclusive proof. So once the court comes to a conclusive proof of one fact on the basis of proof of another fact, it is imperative for the court not to invite contra evidence. That is very important. Then we will go to the most important provision of the Indian Evidence Act, section 112. Section 112 paves way for presumption as to paternity. The section commences with the following words: birth during marriage is conclusive proof of legitimacy. The fact that any person was born during the continuance of a valid marriage. Please, friends, underline the word valid marriage. It requires a relook now. The fact that any person was born during the continuance of a valid marriage between his mother and any man, or within 280 days after its dissolution, that is the gestation period of a child, the mother remaining unmarried, shall be conclusive proof that he is the legitimate son of the man. So section 112 paves way for a conclusive proof. What is the conclusive proof? That the son is the legitimate son of the man when the fact that any person was born during the continuance of a valid marriage. First ingredient is it must be during the continuance of the valid marriage between his mother and a man. Please bear in your mind that the act does not use the word father, because according to law of the land, motherhood is a fact and fatherhood is a faith. Unless the mother tells who is the father, the child may not know who is the actual father at all. So it was born between his mother and any man Or in case of dissolution of marriage, divorce, the child is born within 280 days of its dissolution. That is the gestation period, and the mother should remain unmarried. If that be the case, the same amounts to conclusive proof that the son born is the son born to the man and the mother. If that be the case, there is no scope for inviting contra evidence. Here, section 112 strikes an important difference. The next two sentences are very important. Unless, so there is an exception. Unless it can be shown, the word used is shown, not proved. Unless it can be shown that the parties to the marriage had no access to each other. So unless it can be shown that the parties to the marriage had no access to each other at any time when he could have been begotten. I repeat once again, unless it can be shown that the parties to the marriage had no access to each other at any time when he could have been begotten. We can substitute the word conceived for the word begotten. So the exception called out is very simple. If the person who questions the paternity or legitimacy is able to show and prove that he had no access with the mother at any point of time when the child could have been conceived or begotten, there can be no conclusive proof. So section 112 paves way for a conclusive proof being drawn, and it also gives an exception to section 4 by inviting contra evidence. The contra evidence is only one small thing, proof of access or proof of non-access. So the entire exception to section 112, that is the conclusive proof, revolves around the word called proof of access or non-access. So the only exception as per the Evidence Act is the proof of access. Now let us go to section 114 that paves for an adverse inference. As you all know, if the court is supposed to draw an inference based on a fact, if a party refuses to cooperate with the court is supposed to draw an adverse inference. This is what is contemplated by section 114. The court may presume the existence of any fact which it thinks likely to have happened, regard being had to the common course of natural events, human conduct, and public and private business in their relation to the facts of the particular case. So then the most important provision of the Constitution of India is Article 21. Sweet and shortest provision of Constitution of India, which says that no person shall be deprived of his life or personal liberty. So this is the general right, a fundamental right given to the citizens. No person shall be deprived. It is available to non-citizens also. No person shall be deprived of his life or personal liberty except accordance with the procedure established by law. So as all other fundamental rights are subjected to a reasonable restriction, protection of life and personal liberty, though it is a fundamental right and finds part in Part 3 of the Constitution of India and cannot be denied, there is an exception always. You know very well that no fundamental right is absolute. Every right is subject to some reasonable restriction. The restriction available to Article 21 is a procedure established by law. So according to section Article 21, it is writ large that a procedure established by law can curtail a right of life and personal liberty. So these are all the provisions in which we are supposed to just go around with the provision. Now I would just jump to the topic straight without wasting much of your time. So the issue under consideration lies in three different stages. Stage number 1 is the stage in which an application is taken out for the purpose of inviting scientific or medical examination, more particularly DNA test. First stage is an application is taken out by one of the parties wherein he is sought for the relief of appointment of an expert for the purpose of conducting a DNA test. The second stage is where an order is passed against a person and such a person is unwilling to undergo the medical examination or sample given for DNA test. Number 1 is the application stage. Number 2 is application allowed, but the person is unwilling to undergo the examination. Third is very crucial, more important. So an application is filed and allowed. The person has undergone the medical examination the results have come. But there is a clash of interest between the result of the scientific test and the conclusive proof drawn under Section 112 of the Evidence Act. Here we are going to face a tight situation where the evidence or the test result available after the examination is contra to the conclusive proof drawn by the court. What is to be done? We'll just see the subject matter one by one. The first point for consideration is the authority of the courts to rely upon the scientific examination or DNA test, whether DNA test is foolproof, whether it is subject to any human error, whether the courts can frown upon or the courts can safely depend upon the DNA test or not was the question. The said dispute is no more res integra. This is a case called the Nirbhaya's case, where the Supreme Court has held, you may just see the citation, that Mukesh versus State, that is NCT of Delhi, where the Supreme Court has conclusively held that this DNA test is accurate and it is conclusive. There is no room for any doubt. So if any doubt is raised by any of the parties, doubting the correctness or veracity or conclusiveness of the DNA test, you may cite this judgment. This is by a larger bench of the Constitution. Next is, I have got some important case laws I'll be referring to when the session is going on. I'll just cite the names of the parties. Gautam Kuntu's case in 1993, the earliest case governing the field. That was the case where the blood test was the acid test. Second is the case law by 3 judges of Supreme Court, Sharda versus Dharamphal, 2003. Then Bhavani Prasad Zina in 2010. Then Banarsi Das versus Tikuram in 2005. More important case law, Kamti Devi's case in 2001. And recent cases called Nandlal Vasudev Badvik and Deepanvita Roy in 2015 and 14 respectively. And the very important constitutional judge bench case law by the Supreme Court of 9 judges in case Puttasamy versus Union of India. This is the Aadhaar card case. And finally, the recent judgment of Supreme Court dated 1/10/2021 in a case called Ashok Kumar's case, wherein the Supreme Court has taken a divergent view by taking recourse under Article 21 and Puttasamy's case law. I'll refer to the case laws as and when it comes once again. You can note it down. Now, let us just go to the first judgment which is to be considered in this matter. Whether the examination of a person for any scientific test, including DNA test, would amount to transgression or violation or infringement of Article 21 is the million-dollar question that has been lingering around the minds of various courts time and again. And unfortunately, I use the word unfortunately, it still remains a debatable point even after 60 to 70 years of independence. So I just want all of you to just go through the judgment of Supreme Court in Sharda versus Dharamphal, 2003, volume 4 SEC, page 493. Here, the Supreme Court has paved way or cleared the way for such a scientific investigation. What is the finding of the Supreme Court in Sharda versus Dharamphal's case is very important. If you go through para 72 and 73, we may find the crux of the judgment. If, for arriving at the satisfaction of the court and to protect the right of a party to the lease, who may otherwise be found to be incapable of his own interest, the court passes an appropriate order. The question of such action being violative of Article 21 of the Constitution of India must also see to it that the right of a person to defend himself must be adequately protected. So what is sought for was the scientific test. What was put forth was Article 21. What was the answer of Supreme Court is simple. You balance between a right of privacy of a person and the legal right of the person who wants to defend the case. Let us just assume an important scenario where husband suspects the fidelity of the wife and he suspects the paternity of the son born to the wife. So it may have a far-reaching consequences. It may be rather disastrous consequences if the child is bastardize if he easily disowns a child. So the courts are called upon to strike a balance. On the one hand, the courts are supposed to protect the institution of marriage, that is the root for our social fabric. On the other hand, the courts are supposed to protect the rights of the parties who have got the right of defending themselves in the manner known to law. This is where the Supreme Court has cleared the way. In para 73, the Supreme Court says, it is however axiomatic that a court shall not order a rowing inquiry. It must have sufficient material before it to enable it to exercise the discretion. Exercise of such discretion would be subjected to the supervisory jurisdiction of the High Court. Abuse of the discretionary power at the end of the hands of the court is not expected. The court must arrive at a finding that the applicant has established a prima facie case before passing such an order. So it is not that the Supreme Court has said DNA test or scientific test is not permissible. It is permissible, but not for mere asking. It is only after a prima facie case being shown that the courts can order such scientific test. This is what the Supreme Court says in Sharda's case. We'll just see the next important point. So, para 75 of the judgment of Sharda versus Dharampal consists of the summation paragraph. And second summation is very important. Passing of such an order by the court would not be violative of right to personal liberty under Article 21 of the Constitution of India. So, what has been held by the Supreme Court by a judge of a bench of 3 judges is very simple, that passing of an order, ordering a person to undergo a medical examination would not amount to violation of the right to personal liberty under Article 21 was the decision of the Supreme Court in Sharda versus Dharampal's case. Then we will move to next important point. Gautam Kuntu's case. This is the earliest case in the year 1993. All the persons who advocate against the scientific test, saying that it violates Article 21, they buttress upon only this judgment as if this is against scientific test. Gautam Kuntu versus State of West Bengal, 1993 3 SCC. But if you go through Gautam Kuntu's case very scrupulously, in fact, the Supreme Court has not decided the issue against scientific examination. I'll just take you to the particular paragraph. Para 24 of the judgment. It says, it is a case on section 112 of the Indian Evidence Act, where the paternity was the dispute. The court has defined what is called access and what is called non-access, and has held what is called a difference between non-access or access and cohabitation, and finally held in para 25 that there can be no automatic allowing of an application. Please see that there are 4 important ingredients of the order. The court in India cannot order blood tests as a matter of course. The word in India is important because by the time Britain has amended the Evidence Act, paving way for examination of scientific tests, etc. So the word is the courts in India cannot order blood tests as a matter of course. Wherever applications are made for such a prayer, in order to have a rowing inquiry, the prayer for a blood test cannot be entertained. There must be a strong prima facie case in that the husband must establish non-access in order to dispel the presumption under section 112 of the Evidence Act. So the test used by the Supreme Court in 1993 in Gautam Kuntu's case is simple. There must be a prima facie case. The prima facie case is in the nature of husband establishing non-access. Non-access is buttressed to dispel the presumption under section 112 of the Evidence Act. If these things coexist, the Supreme Court said, you can go for the blood test. Then the court also said, before ordering so, the court should be careful in following the consequences of ordering such a blood test. Then we'll just go to an important case. This is a case where the Supreme Court has discouraged a situation where a scientific examination result would dispel the presumption under section 112. This is a case where a scientific examination is pitted against the presumption under section 112. The Supreme Court has ruled, it can be found in para 14 in Kamti Davis case, that the standard of proof in such a case is at least of between 2 as to ensure that there is no possibility of the concealed through the plaintiff's judgment. So the Supreme Court has been very, very clear in stating that please don't attempt to dispel the presumption available under Section 112 on the basis of a scientific test. So this has been once again buttressed by the Sixth judgment by saying that the presumption is under a maxim, and marriage and filiation is a matter of presumption, and the law in general presumes against vice and immorality. The Supreme Court further held in Kuntu Devi's case that such a presumption under Section 112 of the Evidence Act can be displaced only by a strong preponderance of evidence, but not merely by a balance of probabilities, as the law has found favor of an innocent child being not bastardized. So proof of non-access between the parties to marriage during the period is the only way to rebut the presumption. So between the scientific test and Section 112 presumption, the Supreme Court favored the presumption of Section 112 and has not favored the results of the scientific test. This is a deviation from Gautam Kuntu's case and Sharda versus Dharampal's case. Then, where the Supreme Court has clearly held, when there is an apparent conflict between the right to privacy of a person not to submit himself to medical examination and duty of the court to reach truth, the court must exercise discretion only by balancing the interests of the parties and a new consideration which for a just decision in the matter such as scientific examination is eminently needed. So the test introduced by the Supreme Court in Kuntu Devi's case is a test of eminent need. Unless there is a proof that there is an eminent need for a contra evidence in the nature of going for a scientific evidence, there should not be any application allowed for the purpose of carrying out a scientific investigation, is the judgment of the Supreme Court in Kuntu Devi's case. So the test is eminent need. Now, the court has held also, if for the third paragraph, if for arriving at the satisfactory court and to protect the right of a person that the least who may otherwise be found to be incapable of protecting his own interest, the question of such action being violative of under Article 21 does not arise. So here also, after holding that there can be no automatic allowing of application for scientific evidence, even after holding that unless there is a strong presumption available, there can be no clash of interest between the scientific test and the presumption, the court says if such a test is allowed after being satisfied of eminent test being satisfied, the application will not suffer the disqualification of the transgression to Article 21 of the Constitution of India. So even in Kuntu Devi's case, Article 21 has been used not as a point against the blood test or the scientific test. Then we can just conclude before going to 2021 case, we can just conclude as follows. The matrimonial court has power to order a person to undergo medical test. Passing of such an order by the court would not be in violation of the right to personal liberty under Article 21. However, the court should exercise such a power if the applicant has a prima facie case and there is a sufficient material available to the court. If the person against whom such an order is passed refuses to undergo the test, the court will be entitled to draw adverse inference. Here, Section 114 of the Evidence Act comes into operation. So after satisfying that there is an eminent need, the court has ordered the application and the person against whom the order is passed refuses to undergo the test, then the Supreme Court says, you are not left without any power. The court may draw an adverse inference if the respondent refuses to comply with the order of the court. So now we have to just see Sharda versus Dharampal, para 74, it clearly says that the court has got power to order DNA test or scientific test, and it is not for mere asking. There is no rowing inquiry. There must be a prima facie case, and it is not violative of Article 21. Now we'll go to next judgment called the Rohit Shekhar case, India Tiwari's case, where the Supreme Court has held, Justice Geeta Mittal, who has since retired as a Supreme Court judge, held that, Jammu and Kashmir judge, held that the courts have got ample power to implement such an order, not only by drawing adverse inference, but also by taking coercive steps. In the matter, finally, N.D. Tiwari yielded to scientific test when the Division Bench of Delhi High Court ordered for coercive steps compelling him to give the blood test. On that stage, N.D. Tiwari yielded and he has acceded to the demand of his son. So there was no scientific test conducted. But the Delhi High Court Division Bench has held in original side appeal that the court has got power to take coercive steps. This is where Article 21 will be pitted against. This judgment may not be a good judgment after the recent judgment of the Supreme Court. Now, we go to the more important point of the third stage, where a result is made available and per contra, the result is against the presumption drawn under Section 112. When these two are pitted against each other, the courts are in a quandary to follow which of the two, either the result available after the scientific test to be followed, or the court should be inclined in favor of the conclusive proof under Section 112. This is the challenge before the court. See, we are supposed to see once again Kamti Devi's case in 2001 5 CCC page 311, where the Supreme Court says a presumption which amounts to conclusive proof under Section 112 by invoking Section 4 of the Evidence Act cannot be displaced by any scientific report or evidence. So, unmindful of Sharda versus Dharampal, which is rendered by 3 judges bench, the Supreme Court in Kamti Devi's case by a regular bench held that the conclusive proof under Section 112 cannot be displaced by any scientific test or report. This was the judgment in force till 2014. The courts were not inclined to allow the application by taking recourse under the Kamti Devi's case and taking umbrage under Article 21 of the Constitution of India. Now comes an important provision. See, I told you already, in the year 1872, when the Indian Evidence Act was enacted, there were no scientific tests. And friends, please mind that Indian Penal Code and Section 125 CRPC and the relevant provisions came much later. And the matrimonial laws, which paved the way for dissolution of marriage, were not in force when the Evidence Act was enacted. So, Section 112 of the Evidence Act was enacted to safeguard the institution of marriage and not to bastardize the children only, in the absence of any other provision under the special act, like dissolution of marriage under the Indian Divorce Act or Hindu Marriage Act, or except the Muslims, there were no provisions for dissolution of marriage in Indian by a codified law. And there were no provisions for maintenance. And there were only provisions for succession certificate only thereafter. So when the Evidence Act was enacted, no requirement was there for the people to go for any other burden of proof excepting defending the issue of paternity. That may be a case in which a suit for partition is laid. Now, the Supreme Court also favored against the scientific test in Banarsi Das versus Tiku Datta's case in 2005. So, in 2001 and in 2005, the Supreme Court held against the scientific test pitted against the conclusive proof. Now, the landmark case came in the year 2014. Nandlal Vasudev Badvaik versus Lata Nandlal Badvaik, where Justice Keher, who was in the judgment, who was in the bench of Nandlal's case, and who was also the judge in later case called Deepan Vida's case, and who was also one of judge in the 9 judges constitutional bench in Puttaswamy's case, held that in the event of clash between scientific test result and Section 112 presumption should yield to the scientific test result. The court, after discussing the veracity accuracy and conclusiveness of the scientific test result, more particularly DNA test result, has found that we cannot keep our eyes closed to scientific advancement. Time has passed by. Law has to give way for scientific advancement. So hereafter, whenever there is a presumption by recourse to theory of access and non-access and the result of scientific test, the result of scientific test only will prevail over, not the presumption. That was the judgment by the Supreme Court in Nandlal Vasude's case. Then the Supreme Court has clearly held so only after discussing the previous cases. The Supreme Court has discussed at length all the previous cases, like Gautam Kuntu's case, Bhavani Prasad Jina's case, Banarsi Das case, and Kamti Dev's case. And based on Sharda versus Dharampal only, by discussing all the previous case laws, the Supreme Court has ventured into old fuss, stating that such a scientific test result would dispel the presumption under Section 112 of the Evidence Act. So you know very well that when there are contradictory judgment by co-equal benches, and the second judgment or later judgment has referred to the former judgments, the later will prevail over the former. That is the law of binding precedents. So in this case, the strength of the bench in Banarsi Das, Bhavani Prasad Zina, Gautam Kuntu, and Kamti Devi were true. So also the judges' strength in Nandlal's case is also true. The only exception was Sharda, that was by 3 judges. The 2 judges bench in Nandlal's case have followed the 3 judges bench of Sharda's case and has discussed at length the previous case laws and held that all the previous case laws were not directly on this point. The Supreme Court has held in Nandlal's case DNA test and the clash of titans between the DNA test and presumption were not the point in discussion. So the Supreme Court held in favor of scientific tests being taken into account. So the very important fact now is to be seen that one more case called Deepanvita Roy's in 2015, little bit later by the same bench consisting of Justice Kehar. It is a case where a matrimonial dispute was there and DNA test was sought to be ordered. The Supreme Court said that the DNA test should not be ignored. It should be taken on consideration as against the presumption under Section 112 of the Indian Evidence Act. Now comes the case which I want to buttress, that is reported in only one journal to my little knowledge. This is 2021 Supreme Today, page 534 Supreme Court. In a case called Civil Appeal number 6153 of 2019, dated 1/20/2021, by a regular bench of 2 judges of Supreme Court, in a case called Ashok Kumar versus Raj Gupta and others. This is a case wherein, after the evidence of plaintiff was over, in which the dispute of paternity was one of the issues, the defendant took out an application for the purpose of calling upon the plaintiff to give further evidence by subjecting himself to medical examination called a DNA test. After dismissing the said application as uncalled for, the Supreme Court has taken a divergent view by taking recourse under the 2019 Constitutional Bench judgment in K.S. Puttaswamy versus Union of India. This is the case where the Aadhaar card scheme was under the scrutiny. Here, the Supreme Court has held that Article 21 is not a mere ordinary right. It is one of the fundamental rights of the Constitution of India, which should be protected by the state. If you have any access to go through the judgment, 2019, Volume 1, SEC, page 1, in K.S. Puttaswamy versus Union of India, I would just request you to go through 2 paragraphs of the judgment. That is the last paragraph of the conclusive paragraph, where the Supreme Court held first part relates to overruling MP Sharma's case. Second part relates to overruling Karak Singh's case. The third point says the right to privacy is protected as an intrinsic part of the right to life and personal liberty under Article 21 and as part of the freedoms guaranteed by Part 3 of the Constitution of India. So, a right to privacy and right and personal liberty is a guaranteed fundamental right which cannot be so easily taken away except under Article 21. Now the question is whether Article 21 is subjected to a restriction. If so, what is the finding of the Supreme Court in the constitutional bench case about the restriction on Article 21? Para 71 speaks of the restriction. I'll just read for your appreciation. Test. Principle of proportionality and legitimacy. The Supreme Court said, the concerns expressed on behalf of the petitioners arising from the possibility of the state infringing the right of privacy can be met by the test suggested from limiting the discretion of the state. Number one, the action must be sanctioned by law. Any action that provides way for a scientific test must be sanctioned by law, and there can be no scientific test without a enabling provision or an enabling law. Number two, the proposed action must be necessary in a democratic society for a legitimate aim. Very important point is the Supreme Court has said that in case of a legitimate aim only, such a course can be taken. The proposed action that is going to violate Article 21 should be taken as necessary in a democratic society only for a legitimate aim and not otherwise. The third is the extent of such interference must be proportionate to the need for such interference. That is called a proportionality. The extent of interference should be proportionate to the need for the interference. So the interference must be equated by equating the extent of interference and the need for interference. It should be proportionate. And more importantly, there must be procedural guarantees against abuses of such interference. So whenever a law is enacted, for example, taking the voice sample of a person, it is still before the Supreme Court. When such law is being enacted, the Supreme Court said there must be procedural guarantees against abuse of such interference. This is the exception the state can impose under Article 21 as per the Supreme Court by a judges of 9 judges of a constitutional bench. Now, the Supreme Court in para 72 of judgment in K.S. Puttasamy has categorically held as follows. The right to privacy, as already observed, is not an absolute right. The right to privacy, as falling in Part 3 of the Constitution, may, depending on its variable facts, vest in one part or the other, and would thus be subject to the restrictions of exercise of that particular fundamental right. National security would thus be an obvious restriction. So would the provisos to different fundamental rights, dependent on where the right to privacy would arise. The public interest element would be another aspect. So in para 72, the Supreme Court has ruled that Article 21 as other fundamental rights is not absolute. The right to life and personal liberty is subject to a reasonable restriction, that is a procedure in accordance with law, and it should be very carefully protected. Now, if you go to para 83, it is very, very clear. The Supreme Court has held in the constitutional judgment, let the right of privacy, an inherent right, be unequivocally a fundamental right embedded in Part 3 of the Constitution of India, but subject to the restrictions specified, relatable to that part. This is the call of today. The old order changed, yielding place to new. So this is the judgment of the Supreme Court in Puttasamy's case. So if somebody says that the Puttasamy's case has ruled in favor of Article 21, please bear in mind that Puttasamy's case is very clear that Article 21 is sacrosanct. It is very important right. It is one of the fundamental right, should be protected. It should not be ordinarily violated. But the Supreme Court at the same time said it is subject to a restriction as in the case of other rights under Part 3, and it can be imposed by state on so-and-so consideration. So Article 21, the right to privacy under Article 21 has been declared to be a constitutionally protected right in India. Now the question is, the judgment in Ashok Kumar's case has held against DNA test by citing the Puttaswamy's case. This is where we stand perplexed. In Ashok Kumar's case, the Supreme Court has held that the court must examine the proportionality of the legitimate aims being pursued, whether the said act not arbitrary or discriminatory, and it is further held that balance should be of taking the eminent test being satisfied. So more emphasis was placed on Article 21 by the bench in Supreme Court in Ashok Kumar's case. Then Supreme Court said in Ashok Kumar's case, the apex court has further held that when the party is unwilling to subject himself to the DNA test, forcing him to undergo one would impinge on his personal right and right of. So even when the Supreme Court in Puttaswamy's case has held that Article 21 can be subject to reasonable restriction by the state by following the test of proportionality and eminent test, the Supreme Court in Ashok Kumar's case held that forcing a person to undergo DNA test would amount to impinging Article 21. The court said it was conscious of the adverse inference being drawn. The court further held that in the event of an order being passed, you pass an order, you draw an adverse inference, but don't compel the party to undergo a test. This is where the Ashok Kumar's case is standing apart. The Supreme Court in Ashok Kumar's case has said that the court can order DNA test on the basis of test of eminent need. The court has also stated that by following the test of proportionality, Article 21 can be subjected to a reasonable restriction by act of a parliament or the law of the state. At the same time, the court says if he refuses to undergo the test, don't compel him. You may take or you may draw an adverse inference. A very important note of difference or striking note of difference that though the three judges bench in previous cases have held that Article 21 is not violated, though Puttaswamy's case has not held that there can be no restriction at all to the right of life and personal liberty under Article 21, the Supreme Court has found a novel way in saying that allow the application, draw adverse inference, but don't compel him to undergo the test. Ultimately, the Supreme Court has dismissed the DNA application by citing the facts of the case also. So the question is, the third stage remains debatable even now. Even after Sharda versus Dharampal, even after Nandlal Vasudev Baidvik's case law, even after Deepanvita Rai's case, because of the Ashok Kumar's case, now we are back to square one. Now we are now in a situation where there is a scientific test available against the paternity on the one hand, and the presumption under section 112 is on the other hand. When the husband is not able to prove non-access, what is to be done? Friends, please bear in mind that proving a negative is very difficult. And the days have advanced. Women are no more confined to four corners of any wall or a building. You can see women going freely all over the world. You can't find fault with the woman going with another man on official duty. So access or no access cannot be the only criterion because of the latest emerging trend in the society. Extramarital affair has become so common. Divorce petition on the file of infidelity has become very common. And the incidence of bastardized children are on the rise. So now we can't say that access is the only way to prove the infidelity of the wife. Because multiple access with different men by a single woman in a single day is possible now. Gone are the days where women were confined to a particular house, they were not supposed to go out. Now it is not the case. So access can never be the conclusive test for a husband or the defendant or anybody to prove the paternity in dispute. In a suit for paternity, if the DNA test is not allowed, you may just imagine the plight of the mother whose fidelity and character is in question. If the son wants a declaration that so-and-so is my father, if the court is not inclined to allow the application, that the mother is now in a quandary. She faces the what is called wreath of being held to be an immoral woman. So these are all the things that may happen in a situation also. So I would just to come to summarize the provision. The courts in India are authorized to direct the parties in dispute, to decide the legitimacy of a child, to undergo any scientific test or examination, including DNA test. Such an order cannot be construed to be in gross violation of Article 21, but such an application cannot be ordered for mere asking, and the court should satisfy it that there exists a prima facie case for such a course, and such a person cannot be such a test cannot be forced on any person. The test of eminent test and test of proportionality should be considered. And if after an order of being passed, if the party refuses to undergo the test, the courts can draw adverse inference under Section 114 of the Evidence Act. And after the scientific examination or test, the courts have to follow the proof. Simply because a scientific evidence is available, it does not amount to automatic proof of the evidence. Like any other expert evidence, scientific evidence is also an evidence only. It has to be proved in the manner known to law. Simply because a scientific test is available before the courts are not supposed to be bound by it. The court has to ask the party who has sought for the opinion to prove it in the manner known to law and subject the witness to cross-examination by the other side. And now, what remains debatable is this. The position of law still remains a debatable point in view of the contrast stance taken by the Supreme Court by different benches over the period, especially the Ashok Kumar case by buttressing into Article 21, because Puttaswamy's case law came only in 2019 only. So before parting, I just want to say in academic interest that members please go through the 185th report of the Law Commission. 185th report of the Law Commission. That Law Commission report is confined to amendment and changes compelled in the Evidence Act. 185th report is meant only for amending the Evidence Act. In the amendment, the Law Commission, headed by an eminent judge called M. Jagannath Rao, he has given the report to the Parliament in 2003. He has recommended two important amendments with relating to DNA test. He has recommended inclusion of Section 9 in the Evidence Act, proposed Evidence Act, where DNA tests are being made as part and parcel of the legislation. And he has suggested an amendment to Section 112 by replacing the old 112, and he has suggested a new Section 112, according to which he has given 4 tests. If a person who suspects the paternity is able to prove the issue of paternity in any 2 tests out of the 4, it can be taken safely as a recourse. That is the amendment sought for by the Law Commission. But unfortunately, from the year 2003 till 2021, the report of the Law Commission has not seen the end of the tunnel. It is still standing before the scrutiny of the Standing Committee of the Parliament. It has not been accepted so far. So I feel that the Parliament should venture into amendment of Section 112 in view of the changing socio-cultural settings, emerging trend among the generation next, and the change of laws, including deletion of Section 497 of the IPC. Now, I request all people here to the August gathering to go through the report of the Law Commission in the year 2003, number 185. So, my suggestion is found in the last 2 paragraphs. The amendment proposed should be in the nature of making the presumption under Section 112 only a rebuttable presumption and not a conclusive proof. If Section 112 is amended and the presumption is made as a rebuttable presumption and not a conclusive proof, the vigor of the proof of access and non-access is diluted. In such an event, the rebuttal evidence is not confined to access or non-access, and it is inclusive of any other scientific evidence test result. So I suggest an amendment to Section 112 by removing the conclusive proof part from the statute book and to permit contra evidence not only by confining to access and non-access, but also taking recourse to scientific test or medical examination, which would serve the purpose. With this, I just close my topic. I leave it to the forum, sir. Thank you very much for the opportunities.
Thank you, sir. Usually we are having an interaction section for 10 minutes. So all our participants are those who wish to ask any question to our faculty. You can raise your hand so that.
Come sir, no audios.
Audible, not audible.
Your volume is low, sir.
Okay, sir. I will raise my volume. Okay. See, all our participants are requested to raise your hand. Those who wish to ask any doubt. Yes, Anish Mani, please. Anish Mani. See, Anish Mani. Anish Mani.
Anish Mani, please ask the question.
I think he's still in mute mode. Anybody wishes to put any respect of the deliberation? Use your hand. So I think since the area is very clear to the audience, there is and moreover the deliberation availability to is available also. So if there is any doubt in respect of this area, we can rehear the deliberation again and again. And so, sir, I think it's we can wind up our session.
Yes, sir. Yes, sir.
See, as I've already pointed out that the speaker is a senior lawyer from Tamil Nadu, and not only is a lawyer, as I already stated while I was welcoming him to this August session, I may make it clear all those things also. So this is the second time when which a lawyer from the Tamil Nadu state is appearing in our platform. Earlier we are having our Shankar Murali sir, though including today's Srinivasa sir. Both the speakers were introduced by Adilakshmi Logamurthy ma'am, who is very much known in the Tamil Nadu area and the legal fraternity. She is conducting webinars for the legal aspirants, and he is very much interested in conducting all those things. I express my sincere thanks to introduce such a nice speaker for addressing the State Bar Council Content Legal Education Program today. And now I express my sincere thanks to Srinivasa Raghavan sir, who is being with us for the last 1 hour and having a nice deliberation on the very good area, which is very useful to the practicing lawyers. And this is also coupled with the personal liberty, how the DNA test and the comparing for going for a DNA test touch the area of the personal liberty, which is guaranteed under the Article 29 of our Constitution. So I think the today's sharing of the knowledge is very useful for us. And sir, I express my sincere thanks for all of the participants as well as the seminar committee for being with us and sharing the knowledge, sir. Thank you very much, sir.
Thank you very much.
Okay, next I like to thank one and all who all are present here, making a grand success of this session, and also to our technical advisor Shamim and Sri Mohiddin sir, and all the other senior members of the State Bar Council, including all the lawyers and other law students, teachers, and other friends who all are present here. Next week we are having on the 82nd session, most probably on the next Saturday evening. So thank you very much. See you on next Saturday. Good night to all. And thank you very much once again. Thank you.
Thank you. Thank you, sir. Thank you.
Thank you.